Ready, start. However, if the decision by the learned sessions judge is to summon the additional accused before passing the judgment of conviction or passing an order on sentence, the conclusion of the trial by pronouncing the judgment is required to be withheld, and the application under section 319 CRPC is required to be disposed of, and only then the conclusion of the judgment either to convict the other accused who were before the court and to sentence them can be proceeded with. This is so since the power under section 319 CRPC can be exercised only before the conclusion of the trial by passing the judgment of conviction and sentence. Though section 319 CRPC provides that such person summoned as per subsection within bracket 1 thereto could be jointly tried together with the other accused, keeping in view the power available to the court under section 223 CRPC to hold a joint trial, it would also be open to the learned sessions judge at the point of considering the application under section 319 CRPC and deciding to summon the additional accused to also take a decision as to whether a joint trial is to be held after summoning such accused by deferring the judgment being passed against the tried accused. If a conclusion is reached that the fresh trial to be conducted against the newly added accused could be separately tried, in such event it would be open for the learned sessions judge to order so and proceed to pass the judgment and conclude the trial insofar as the accused against whom it had originally proceeded and thereafter proceed in the case of the newly added accused. However, what is important is that the decision to summon an additional accused either suo motu by the court or on an application under section 319 CRPC shall in all eventuality be considered and disposed of before the judgment of conviction and sentence is pronounced, as otherwise the trial would get concluded and the court will get divested of the power under section 319 CRPC. The High Court, in exercise of its revisional jurisdiction, was justified in setting aside the order passed by the trial court rejecting the second application preferred by respondent number 2 under section 319 of the CRPC, as the same was found to have been passed contrary to the settled position of law. Once a superior court deems fit to interfere with an order passed by a subordinate court, then any rectifications to such order passed in exercise of revisional powers under section 401 read with section 397 of the CRPC must be treated on the same footing as rectifications made by an appellate court, and as a result would relate back to the time the original order was passed. By virtue of relating back of the order passed by the High Court in a revision petition, the summoning order passed by the trial court in compliance with the order of the High Court would also relate back to the initial order rejecting the second application under section 319 CRPC.